My name is Volker Kruger and I'm joined by Janus Olivier. Many of our listeners have probably heard or read about the Property Practitioners Act that recently came into operation. The purpose of this discussion is to maybe shed some more light on this act and how it will affect estate agents, developers, managing agents, etc. So thanks for joining us, Janus.
It's a pleasure, Volker.
The date when the act came into operation?
1 Feb 2022, so it was earlier this year. The full citation of the act is obviously the Property Practitioners Act 22 of 2019, so we knew about it since 2019. But yeah, it's now been advertised in the Government Gazette that it came into effect 1 Feb 2022. Replaced the old Estate Agency Affairs Act, which has already been in operation for more than 40 years. So it was maybe time for a replacement. So that's since 1 Feb 2022, we now have the new act.
Objectives of the act, if you maybe need to summarize it in a nutshell, I guess it's similar to the old act, the Estate Agency Affairs Act, but there are also a couple of new things. But how would you summarize what you think the legislator is trying to achieve with this legislation?
Okay, summary, to govern the whole property sector and not just the state agents, as was the case with the previous act. So it's for the whole property sector, and then also to promote transformation of the property sector as well. We'll maybe discuss it later on as well, but there's now a requirement that for you to get a Fidelity Fund certificate, you must have a valid BE certificate as well. There's no minimum requirements yet, but you must have a BE certificate. So basically the twofold purpose of this new act, in my opinion.
You mentioned that it now applies to not only estate agents, so that I guess it is also a very important development.
Yeah, as you mentioned in your introduction, now it's bond originators, providers of bridging finance, managing agents of sectional schemes or community schemes rather, and then, as it always has been, estate agents, property developers. So the Act introduces this new concept of the property practitioner, hence the name Property Practitioners Act. So the idea is that if you fall under this definition of a property practitioner, you will be governed by the rules of this Act. You can apply to be exempted from the Act. I know there are talks of mortgage originators who have applied, but I don't have any further details of that, so we'll keep our ears on the ground in respect of that. And then for developers, I can maybe add there are a bit of uncertainty or unhappiness, in my opinion, due to poor draftsmanship of the Act. In this definition of a property practitioner, there's basically one section where it appears to create an exemption for property practitioners, in essence saying property or property developers rather, you will be a property practitioner if you sell your units in your development, unless you use another property practitioner with a valid Fidelity Fund certificate, which makes sense in my opinion. But then the very next paragraph, it says any person who sells a unit in a property development is a property practitioner. So that's maybe a bit ambiguous. On the one side, as I said, there's not the exemption, and then just the next line, it says, by the way, regardless of the exemption, any person who sells property in a development is a property practitioner as well. So for the time being, until there's proper clarity by either the way of an amendment or maybe someone that goes to court, we are interpreting it as if property developers will have to comply with the Act as well, because they qualify as property practitioners.
All right. I think there's also a reference to ordinary course of business. So if you just sell your house as such, where you've been living, it's not part of your business to sell houses, then you're not affected by the Act. Is that correct?
Yeah, so there's, as I say, there's different paragraphs of the definition now of a property practitioner. Now, one of them is if you as a person, you're not acting in your ordinary course of business, it's just a natural person selling his property. I mean, surely the idea isn't that you are now a property practitioner, but it's in another paragraph that it refers to anyone who actually sells a property, part of a property development. But yeah, Volker, in my opinion, the general rule and the idea behind this is, of course, to govern property practitioners and not the average Joe on the street who's just selling his property.
Property valuers, inspectors, attorneys, I think they're also exempted. Is that right?
Yeah, attorneys are specifically exempted in the Act. Valuers, they're not mentioned specifically. I mean, they don't really deal with the money on behalf of clients. So, in my opinion, and as far as the definition of a property practitioner is concerned, a property valuer is not a property practitioner.
Okay. So, if you now are covered by this Act, I guess the next question is, what is the effect thereof? One is the Fidelity fund certificate that you have to obtain. So if you're a property practitioner and you're not exempted, state agent, managing agents, developers probably, then you need to get such a certificate. Is that right?
Yeah, Volker. So from the estate agent's points of view, nothing new there. They always had an obligation to get Fidelity Fund certificate, but it's now all these new entrants into the industry that will need to be or to obtain a Fidelity Fund certificate as well. And estate agents in particular were concerned with this development because they were already waiting very long to get their Fidelity Fund certificates. Actually, the Estate Agents Affairs Board wasn't very effective there. And they were, of course, concerned that if everyone else now has to apply as well, they will wait even longer. It's going to create a bottleneck. But in this regard, I can maybe add that Section 47 luckily says that it's now only a requirement that you renew your Fidelity Fund certificate once every 3 years, so no longer on an annual basis as it used to be. So that will, of course, assist with the bottleneck. And then Section 49 provides for mandatory time periods within which your application must be considered by the property practitioners regulatory authority. That now is just a new name for the old Estate Agency Affairs Board. So they must consider your application within 30 working days. It can be extended with a maximum of a further 20 working days. So you're looking at a total of 50 working days, of course. And if they then don't consider your application, it's actually deemed successful. So you can then apply in writing for them to issue you with your Fidelity Fund certificate if you didn't hear anything from them. And they must actually issue it then within 10 working days. Whether they will do this or not, I don't know, but that's what the Act caters for in this regard. Something else that can be of importance is that...
So sorry if I interrupt you, but so because of that deeming provision, at least it's not your problem. If it's not your fault that you're still waiting for the authority to issue the certificate, it's deemed that you have one, basically, no? So you can carry on.
Yeah, that would be my opinion. As long as you can show, listen, I have complied, I've submitted my application in time, and I didn't hear anything back, I am deemed to have a successful application. Yes, okay. I agree.
Yeah.
With regard to the renewal, as I was about to say, your application must be lodged before 31st of October in the year during which your Fidelity Fund certificate will lapse. Otherwise, you can pay a penalty, a late submission penalty. I can't remember the specific amount now, but it's not a lot of money. But you still would, in my opinion, need to get your ducks in a row. I mentioned by way of introduction that you would need a valid BE certificate. You're also going to need a tax clearance certificate for your business before you can actually obtain a Fidelity Fund certificate. So it would be important that you get these two certificates before the 31st of October. Otherwise, you won't be able to apply for your Fidelity Fund certificate. Now, I don't think the penalty is going to be the main concern here, but if you cannot successfully apply and your Fidelity Fund certificate lapses by the 31st of December, then you're going to sit with a big issue under the terms of the new Act.
And if you apply for the first time, then it's also 31 October this year, I suppose.
Yeah, well, it will still be valid. You must just apply. There is a time period of 6 months, I think, if memory serves, during which you can apply and get your affairs in order under the terms of the new Act.
Right. You mentioned the BE certificate. That, however, does not mean that a certain level is required. I think it's any level 1 to 8 that is acceptable as long as you have a BE certificate. Then it's fine. You can lodge that, and then you've complied with that requirement.
Yeah, I suspect that maybe this will develop in years to come. And if you, for example, want to render a service to the state, they will have their own internal policies that they can only give mandates to property practitioners with a BE level, for example, above 4. Well, 4 or higher. But yeah, there's no prescribed minimum level in the Act at this stage, Volker.
So I guess that's good news for those state agencies that maybe do not have a certain BE level that they have achieved. Once again, as long as you have obtained a certificate, even if it confirms that you're level 8, which is basically the lowest level that anybody can achieve, then you're okay. And I suppose part of the reason for that is also for the authority to be able to track the transformation of the industry, because they will then have records of the BE status of all the agencies issued with the certificates. So I guess that's also one of the benefits that they will then have. Maybe just in terms of commission, many would know that in terms of the old dispensation, you couldn't claim commission if you didn't have a certificate. Similar provisions in the new Act.
Yeah, Volker, the wording is basically if you don't have a Fidelity Fund certificate, you're not entitled to commission or remuneration. So if you're not entitled to it, means you cannot claim it as well. So with the old State Agency Affairs Act, it was exactly the same. But if you did receive your commission, no one really batted an eye that an agent without a Fidelity Fund certificate actually got commission. But now in terms of the new Act, and that's maybe something additional to the fact that just you're not entitled to your commission, conveyancers are actually now also obliged to ensure that they have a certified copy of the relevant property practitioner's Fidelity Fund certificate before they pay commission or any remuneration to that property practitioner. And that certificate must have been valid at the time the transaction was concluded, as well as at the time that the payment of the commission is to be made. And if you, for example, pay the commission without having the certified copy, you as the conveyancer can get a penalty of 7,500 Rand. So that's just something extra that the legislator built in there to ensure compliance with this. Then in addition, Section 48 says that if an estate agent or a property practitioner received remuneration when he or she didn't have a Fidelity Fund certificate, then any relevant party can actually institute a claim and say, please pay me back my commission. And if the property practitioner then refuses to do so, he will be liable for a fine of 10,000 Rand, and of course he will still have to pay the commission back as well. And then there's actually a third, and in my opinion, a more daunting obligation on property practitioners, and that is that once again in terms of Section 56, which places the obligation on conveyancers to get copies of the FFC, property practitioners also have an obligation to automatically, in other words, without having been requested there to buy a seller or purchaser, to automatically pay commission that they received at a time when they didn't have a valid FFC, to pay that to the property practitioner's Fidelity Fund. And if they didn't do that, then they can also get a penalty of 7,500 Rand. So if they did that, as they are supposed to do, then a relevant party now has 3 years to institute a claim for that commission from the fund. And if they don't do that, then the money becomes the property of the property practitioner's Fidelity Fund. But the consequence of this would be, for example, you can just imagine you had a transaction as a property practitioner 2 years ago. Now suddenly the seller finds out you never had a Fidelity Fund certificate. He requests you to pay back the commission. You're refusing to do so. Maybe you don't have it anymore. I know we all know it's difficult economic times at this stage. That client now lays a complaint. He will now be required to then pay back that money. You're going to firstly get a penalty as property practitioner, 10,000 Rand for refusing to pay it back to the relevant stakeholder. You can get another penalty of 7,500 because you didn't automatically pay it over to the fund as well. And your conveyancer is going to get a penalty because surely he didn't make sure that he has a certified copy of a valid FFC. Yeah, so it's definitely some big changes in this regard versus the old State Agency Affairs Act, which I think gives the Act a bit more teeth, and I appreciate that, yeah.
I see here in my notes there's also an obligation to prominently display at your place of business the FFC, in other words, the Fidelity Fund certificate. Also on letterhead and marketing material, you need to indicate that you are registered with the PPRA, in other words, the Property Practitioners Regulatory Authority.
Yes.
Also in agreements, you need to confirm that you warrant basically the validity of your Fidelity Fund certificate as the date of signature of the agreement. So there are a couple of important requirements that I think specifically the state agents should take note of. But anyway, let's move on. Maybe trust accounts. In terms of the old dispensation, there was an obligation to have a trust account if you receive trust money from purchases, etc. In the new act.
Well, basically, still the same. For the general rules is that every property practitioner must have a trust account. You can also apply for an exemption not to have a trust account. For example, if you never had a trust account, or if you, if you not received any money from any clients, or if you used to receive but you are no longer receiving money from clients that you would have to keep in a trust account, you can apply for an exemption. Maybe something interesting there is that in terms of regulation 2.5 and 2.6, it says that a property practitioner who doesn't operate as a property practitioner business, in other words, as a sole practitioner, they are exempt from operating a trust account. And then with regards to managing agents of body corporates, the Act also says that if that body corporate receives funds opened in a bank account that's opened in the name of the body corporate, then it's fine. They don't have to open a new trust or a separate trust account as well, even though they are still property practitioners.
The mandatory disclosure form in respect of defects in the property, I've noticed in the last month or so, many people are already aware of this, estate agents specifically, but even other members of the public that I've dealt with seem to be aware of this new form that is now required. Please explain what is exactly the requirement in the Act?
Yeah, Volker, the newsletters and articles were full of this mandatory disclosure form. It's a prescribed form that's given in the regulations, and it's basically a list wherein the seller or the lessor needs to answer questions about the state and condition of the property. Now, the Act is quite strict in this regard. It actually says that an estate agent or a property practitioner isn't allowed to even accept the mandate from a seller or a lessor before first getting the signed mandatory disclosure form from the seller or the lessor. Practically, I don't see how that will actually work. We can all just see how this wouldn't really work in practice. But the idea is then that the purchaser must get a copy of that mandatory disclosure form so that he can see what the seller thinks are the problems with the property. Is the roof leaking, for example, or is the swimming pool leaking? But this form specifically says that it's not a guarantee or a warranty about the condition of the property. It's just an obligation, and it must be signed by the purchaser as well. The form must be part of the sale agreement at the end of the day. But then the Act goes further and says where a sale agreement was concluded without this mandatory disclosure form, it doesn't invalidate the agreement, but it will now be interpreted as if no defects were disclosed to the purchaser or to the lessee, and then the property practitioner can be held liable by an affected purchaser or lessee, and once again penalties. You can get a penalty of 15,000 rand. So if I were a property practitioner, I would ensure that I get that mandatory disclosure form.
So the food stewards clause that is included, pretty standard in most agreements. What about that? Would that still be enforceable?
My idea is it would still be enforceable. Food stewards clause is more to protect the seller from latent defects of which he didn't know. So my opinion is if the seller didn't know of the latent defect, he wouldn't have been able to disclose it as well. So the Act is now just the transaction is now just interpreted as if no disclosures were made to the purchaser, but the purchaser would still, in my opinion, have the obligation to prove that Mr. Seller, you knew about this defect and you failed to disclose it to me, so the food stewards clause won't cover you. But if the seller didn't know, he would, in my opinion, still be protected by the food stewards clause. I mean, you cannot expect him to disclose something in a mandatory disclosure form which he didn't knew of.
Yeah, I think you're right. So I don't think that really, in essence, changes the enforceability of a food stewards clause in principle. However, keep in mind that there is, of course, the Consumer Protection Act, which in any event invalidates a food stewards clause where the seller was selling the property as part of the ordinary course of his business, or in the ordinary course of running his business. So a seller who is a developer or even a speculate in property, etc., would in any event not be protected by the food stewards clause. But someone else who just sells a property, it's not part of his business. In principle, I would also think that the food stewards clause is still enforceable. And I note that, as you mentioned now, the form that you referred to with the list of stuff to be checked and confirmed, etc., is in the regulations. So I would actually suggest that any estate agency makes that form part of their standard agreement. So that's always part of the process that they follow to get the agreement negotiated and signed. And I guess also part of any mandate that they get from the seller to make sure that you comply with that first requirement that you referred to, namely that you need to get that mandatory form regarding the defects in the property before you actually accept the mandate, which I agree is not going to be that easy to comply with in practice, but I would think that it makes sense for all estate agents to make that list part of their standard mandate as well. All right, record keeping. I see there are certain requirements in that respect as well. What can you tell us there?
Volker, in a nutshell, record keeping, property practitioners are basically, they need to keep records of everything, all the communications which they had with clients for a period of 5 years rather. And it specifically refers to all electronic communications as well must be kept by the property practitioner. So that's basically in a nutshell, without now elaborating on which records. In a nutshell, all electronic communications must be kept.
But that can be done electronically. It doesn't have to be hard copy. So at least you can save it somewhere, electronically as such, no?
Yes, 100%.
Communication on social media, WhatsApp messages. Do you have to save all of that as well?
Well, strictly speaking, you'd need to save that as well. I don't know how that's going to work, because WhatsApp nowadays, I can delete my own conversation. So would you now be in breach of the provisions of the Act if I, as the client, deleted my own conversations and you don't have record of that anymore? The regulations specifically say in this regard, your obligation to keep records of all your electronic communications, it doesn't extend to electronic communications that was made on social media, which are generally accessible by members of the public. So hopefully my WhatsApp messages isn't generally accessible by members of the public. So that means I need to keep that records as well. Yeah.
Okay. All right, moving on to complaints. In terms of the Estate Agency Affairs Act, there was also mechanism provided for, but in the new Act, how does that work?
Okay, any person can lodge a complaint. It's in terms of Section 28. There's a prescribed form as well. The regulations give quite a brief set out of steps to follow, how the mediation and adjudication process would work, taking an adjudication on appeal. So you can really just have a look at the regulations in that regard. Maybe just something that I can briefly mention, if on the request of a client, or if the regulatory authority feels that this specific issue can be resolved by way of mediation, it will first go for mediation, and then the second option is then adjudication, where a legally qualified person will be appointed as an adjudicator. That's an independent person. That adjudicator can request additional help by way of independent assessors, and then they can make a finding, and a finding by the adjudicator will actually have the same status as an order of the magistrate's court. And then, as I said, of course, if you're unhappy with that decision, you can take it on appeal, and the regulations will guide you through that process as well.
All right. So if you're unhappy about an estate agent or whatever, then you can approach the authority and follow this process instead of going to court. And then if the adjudicator makes a finding, that's as good as a court order. So I guess it will also depend on how effective the authority is going to operate in the future, which we obviously don't know yet at this stage, whether it will be better to approach the authority as opposed to going to court. So we'll obviously keep an eye on that and see how it develops. All right, so the adjudicator can then make a finding, and that's like an order, like, for example, you have to pay back the commission or whatever the case might be. But then obviously they can also impose fines if they find that the property practitioners breached or didn't comply with the Act. Is that right?
Yeah, exactly. As I previously mentioned, some of the fines. So you would, as a consumer, as a client, you'd go to lay a complaint and say, this property practitioner, for example, didn't have a fidelity fund certificate. I've requested him to repay my commission, and he's refusing to do so. So I am now laying this complaint. And then, of course, they will impose the penalty that is catered for in the regulations. Yeah.
I see here there's also a fine or imprisonment up to 10 years. So I guess, yeah, it certainly makes sense for all property practitioners to try to comply with the Act. And then obviously the authority could also potentially withdraw your FFC if there's a certain serious transgression which has far-reaching consequences. So I guess the message there is clear, loud and clear, that you should rather comply with the Act at all times. All right, what else? Inspectors, I see there's reference made to inspectors.
Yeah, basically policemen, I would argue. So the Act caters for inspectors to be appointed, and they can rock up at your business within, well, any time, actually, obviously not midnight when you close, and then they can request access to certain records that you should keep, and they can then ensure that there is compliance with the Act. If you are a sole practitioner that, for example, operates from your home, then they must give you reasonable notice. They cannot just rock up at your home. But yeah, for as you have a franchisee or a business, they can arrive suddenly and then request your cooperation, and they must have proof that they are indeed inspectors appointed in terms of the Act. I think the Act caters for an identity card that they will get, so you can request that as well. Obviously, don't just allow or give your records to anyone. But yeah, that's something new as well that the Property Practitioners Act caters for, Volker.
Training. I see they tried to introduce a couple of new things and make sure that the level of expertise, I guess, of property practitioners is improved. Any comments on that?
Yeah, well, it has always been part that for you to get your Fidelity Fund certificate, you don't just apply for it and get it. You must comply, or you must complete certain well, not diplomas, but you must complete certain courses and at least prove to the satisfaction that you have actually met these requirements. So it will be the same in the new Act. The regulations cater for that as well and says what you would need. I suspect at the end that they would maybe differentiate between different property sections. For example, property developers and estate agents wouldn't, in my opinion, need the exact same training in order to get their Fidelity Fund certificate. So I don't know if that is already the case, but I suspect in future they would change it, because I know if you are, for example, wearing two hats, you are you providing breaching finance and you are an estate agent, you need to apply for a Fidelity Fund certificate for both these industries. So it would then, in my opinion, also make sense that there would be different training for them as well, different training requirements.
Okay. I see there's practical training prescribed as well. There must be active supervision and control of any new property practitioner by an agency principal or qualified agent for a certain period of time, etc. And then there's also continuing professional development that the Act requires over a certain period of time as well. A code of conduct, part of the Act is also to have a couple of rules that property practitioners have to follow when they deal with clients, when they deal with negotiations, etc. What can you tell us there?
Yeah, Volker. Section 61 caters for a code of conduct, and then Section 62 actually says they are sanctionable conduct, and one of these rules in Section 62 is that if you contravene one of the provisions of the code of conduct now in Section 61, which is, for example, that you as a property practitioner may not accept a mandate if it requires certain skill or knowledge which you don't have, or the code of conduct also says you as the property practitioner must inform parties that if they don't agree where interest will go to, that for trust money that you have now invested on their behalf, if they don't agree who gets it, you will pay that to the property practitioner's Fidelity Fund. So yeah, there is a code of conduct, and I would advise actually all property practitioners to read through it and take note of it. I mean, you cannot apply the law if you don't know it, and ignorance will not be an excuse for you.
Yes. I see there's also something about sole mandates.
Yeah, so mandates interesting developments as well. The Act, for example, says you are not allowed to accept sole mandates in certain scenarios. For example, if your sole mandate has a provision that says even after the period will lapse, let's say you have a sole mandate for 3 months, but your mandate also says, FYI, the property practitioner will still be able to carry on as property practitioner and retain the sole mandate. That's obviously not allowed. And you cannot have a clause in your sale or rental agreements that gives the property practitioner the sole mandate after conclusion of that agreement, that only that property practitioner will now have the rights to sell or let that relevant property. So in that regard, yeah, you can have a look at Regulation 34.3 as well, that sort of gives all the rules of what is allowed when it comes to sole mandate specifically.
Kickbacks between mortgage originators and agencies, attorneys and agencies, also prohibited.
Yeah, undesirable practice, Volker. I think we all know that you don't need to go and have a look at the Act. If you feel that you are on the edge and you want to go and look at the Act to make sure you are coloring between the lines, you are, in my opinion, it's going to be an undesirable business practice. You can go and have a look at Section 63. There are, as far as I can tell, no monetary penalties imposed, but it is still prohibited. This undesirable business practices. For example, the Act says you as a property practitioner cannot enter into a deal with a property developer or the manager of a sectional title scheme, the body corporate or homeowners association, wherein they get a kickback, they get money in order for preferential treatment to you. You cannot, for example, say, please only open the gate of the sectional title scheme for estate agency A and not to estate agency B. That's undesirable business practice.
Yeah, so the Act, I think, also tries to encourage competition, which I guess should be welcomed in terms of consumers having that benefit of choice. All right, I think that gives a good overview, I hope, of the Act. Obviously, with all these discussions, we've got to warn our listeners that it's a general discussion. General guidelines are given. Please don't take any final decisions based on this advice or these points that we have made during such a discussion. Talk to your attorney, make sure that you comply with the relevant provisions so that you don't have any fines imposed against you or your Fidelity Fund certificate withdrawn or whatever the case might be. Anything else that you want to add, Janus, or would you agree that that is a good summary of what the Act and the regulations? It's a fairly lengthy document. The regulations are actually longer than the Act, I think. So, I hope that gives all our listeners a good idea.
Yeah, no, I agree, Volker. That's basically, we went through everything, the most important aspects and the major changes brought about by the new Act. And with regards to the regulations, they are quite long, but it's really, really brief, and it sets out all the processes, gives an example of all the forms, how your notices will look like. So if there's any doubt, you can go and peruse the regulations.
Also, the exemption applications are, I think, catered for in the regulations. So yes, apart from that mandatory disclosure form for the defects, you can also get the application forms for the exemption. Well, the exemption from the Act as such, and also the exemption from having to have a trust account. So both of those, you can just follow the process prescribed by the regulations to get that exemption if necessary.
Yes.
All right. Thank you.